The introduction, then we'll jump on. Hello, everybody. My name is Brian Sanyamondo, and welcome to another edition of Crypto Mondays Caribbean. And as always, I'm so excited having, an exciting panel of experts who are literally the OGs in their respective fields. And today, I'm going to start with the ladies as usual. We have Lisa all the way in the UK, and we have Leah. She's somewhere in Argentina right now. They're going to introduce themselves respectively. We have StephX on the call. We have Keniel Ledgister, and we have Andrew. So, guys, welcome to the call. And I'd also like to send a massive shout out to my students. I can see them, Alessa and Winifred and Asteria. Thank you for joining. So big up yourselves. And let's have a good webinar today. So, Lisa, I guess you'll take it off with introductions.
Thank you so much. I'm Dr. Lisa Cameron. I was an MP in the UK Parliament up until May of this year. And during the past 9 years of my time in Parliament, I started to chair the cryptocurrency and digital assets all-party group, which was a first of its kind in the House of Commons. So thank you for having me today. I'm very, very keen. My work in Parliament was all about supporting and championing the potential of the industry, and I want to continue to contribute. So thank you for having me here today.
Thank you, Lisa. Leah?
Hello, everybody. My name is Leah Glaentzlin. I am Venezuelan, a Venezuelan attorney practicing in several countries of Latin America. I started as an international and foreign investment advisor. Then things moved into venture capital investments, and that's how I got in touch with blockchain and all its potential. Currently, I'm a certified crypto asset professional by ITCAP and an Agile certified project managers. So that's how I'm involved in this kind of projects.
Thank you, Leah. So I'm going to go to the gentleman now. StephX, I'm going to start with you.
Awesome. My name is Steven Sargeant. I worked in the cryptocurrency investigation space, working for large crypto exchanges consulting. One of the biggest ones was Bitfinex, a sister company of Tether. I worked more on the investigation side and training and helping more compliance professionals in the traditional space come into the crypto investigation space. But because we had such a small team working with Bitfinex, I got to a lot of exposure to regulatory working groups through Interpol, FinCEN, FinTrack, which is our Canadian regulator. So I'm enjoying the opportunity to share some of my insights with this well-established panel.
Thanks, StephX. Keniel?
Hey, good afternoon, good evening, everyone. Pleasure to be here. My name is Keniel Ledgister. I am the Attaché for the Internal Revenue Service Criminal Investigation under the Department of Treasury. As Attaché and liaison, my focus is, as IRS, the enforcement arm of the Department of Treasury, is focusing on all financial crimes, whether cybercrime related or your traditional money laundering, tax evasion, and of course, anything that applies to crypto. I cover the Caribbean region, and that goes from Bermuda all the way down to Trinidad and Tobago, 26 islands specifically. Pleasure to be here. Look forward to this great conversation and lend my expertise in financial crimes, money laundering, and everything crypto.
Thank you, Keniel. Now, Andrew.
Thank you, Brian. Hi, everybody. I'm delighted to be on this panel this evening. I'm a barrister, so I'm a court advocate and attorney. I was called in 1988. I'm based primarily in London at Littleton Chambers, but I'm also a member of the Law Library in Dublin at the Irish Bar, and also the DIFC courts in Dubai. My practice is primarily asset tracing, breach of contractual and fiduciary obligations, and a lot of banking, financial services disputes. So I'm very keen on the regulatory developments that are taking place in England, because I've been dealing with regulatory work for quite a number of years. And finally, I've been involved in a number of recently reported crypto asset tracing successes, which is good. So I'm very grateful to have this opportunity to let you know a few sort of tricks of what's been happening, and I've been looking forward to it. So thank you all.
Thank you, Andrew. Now, Andrew, we're going to come right back to you, because we want you to open the show for us today. So do you want to tell us a bit about your practice in the UK? What sort of cases have you worked on, and how have you seen the legal development of blockchain and crypto in the UK?
I've dealt with quite a number of cases involving romance scams, for example, also hacking cases. Now, the distinction between the two, of course, is that ordinarily, if a would-be investor has been scammed into entering into what they think is a legitimate investment, the initial cause of action will be deceit, and that will be the tort of deceit. However, if it's a hacking claim, deceit doesn't arise, and then you have to rely on the restitutionary claim of unjust enrichment. So ordinarily, in the usual course of events, the causes of action would be deceit, and it would also be unjust enrichment. What ordinarily happens is you'd go to court without notice, ex parte, as it used to be called in the UK, and seek a freezing injunction. That might be an ordinary freezing, worldwide freezing order, or it could also be a proprietary freezing order if your expert is able to trace the crypto assets into a particular wallet. Now, there was a recent case in England and Wales just over a week ago called Deloyer, and in that particular case, the judge dismissed the claim brought on behalf of the investor, primarily on the basis that the issue of causation wasn't satisfied. And so in other words, they weren't able to trace the stolen crypto asset into the wallet that they had effectively put before the court. But the judge then went on, by way of obiter, to refer to what was required by way of expert evidence. And there's a lot of references to FIFO, first in, first out, for example, and as we know, the various combinations that arise in breach of trust cases, where there is a pot, as it were, and a number of claimants, each having a bona fide claim, and the issue of dividing what's in the wallet. So that does have some practical relevance. But my take from that, Brian, essentially is, having dealt with these cases in court for the last 4 years and on a regular basis, is the expert evidence is key. It's because, and obviously a proprietary claim is a lot easier to prove than a personal claim. And if you're able to follow that crypto asset into a particular wallet, the chances of recovery are greatly enhanced. But also, as well, the judges will be aware that the primary guidance in terms of the issue of expert evidence will obviously come from the expert, and they want to be satisfied, and they want comfort from the particular expert. Now, given the judgment in Deloyer that was published, as I say, just over a week ago, in my view, judges are going to be all the more alert as to the soundness and credibility of the expert evidence that's put before the court. So my first advice would be that the expert evidence has to be absolutely spot on, because if it isn't, you're entering into a whole world of hurt, quite frankly. And Deloyer is a very sobering example, because I think the actual loss itself was only in the region of 300,000 to 400,000 sterling. Apparently, the costs are well into a seven-figure sum. So this issue of disproportionality and unreasonableness of proceeding is obviously an issue that does take center stage. In terms of advancing the claim, Brian, assuming that the expert evidence you've got, you're satisfied with it. In the UK, we will seek an order, ex parte order, as I say, without notice order, against the initial fraudster. So to use criminal law parlance, the thief. We will also then include as a second defendant the handler or the beneficiary. In organized crime group scenarios, which a lot of these cases in my experience are, D1 and D2 are all part of the same enterprise, criminal enterprise. The third defendant that we issue a claim against is the bona fide purchaser without notice. So obviously that entity doesn't play any particular part, but it's a signal, it's a siren to the rest of the world and judges overseas that the English judge has borne in mind that there will be effectively an exit route for somebody who is a bona fide purchaser. So those are the three main defendants, 1 and 2 being the active participants. What ordinarily happens in a situation in which there is a viable following or a tracing claim will be to include an exchange as D4, and sometimes there might be 2, 3, 4 different exchanges. And that then arises on the basis that you're not making a substantive claim against the exchange. What you usually are doing is making a claim for disclosure. So in England, it's called a Bankers Trust order and a Norwich Pharmacal order. So it's more of a procedural application that's been made against them. You are also, if the expert evidence warrants it, you're also making a claim for them to effectively deliver up the crypto that in circumstances where the argument runs that there never was a contract that required to be rescinded because it was a scam right from the outset. Now, obviously, as we know, exchanges may well argue that there was an actual contract, you entered into it, and therefore the guillotine falls at a much later time. So that there could well be arguments in respect of that. But nevertheless, so the theory it goes, you will join the exchange, as I say, for disclosure, but also for delivery up. And the recent Deloitte case is a useful authority where the deputy judge, he extensively, as I say, obiter, because the ratio of the case was causation hasn't been satisfied, so that's the end of it. But he then very helpfully went on to provide his view on what the law is. It's deputy judge called Richard Farnhill. The decision was handed down on the 12th of September. And effectively his view was that if an exchange is notified of the fact that stolen crypto has been transferred into a particular wallet at their exchange, they're under an obligation then to deliver up, to transfer that crypto back to the original investor. If, after being notified of the fact that there has been a scam, there's been a theft, what Farnhill's decision, as I say, it is by way of obiter, but nonetheless, it does helpfully set out the legal principles. What happens is that the proprietary claim goes out the window. Of course, that doesn't exist any longer because the asset isn't in the wallet. However, the claim then morphs and transmogrifies into a claim for a personal claim for knowing receipt against the exchange. So essentially, the point I'm making is it's an incremental. There is no quick answer to this, and that's another aspect of all this that clients, obviously they're distressed, as we know, in these sort of egregious, pernicious forms of theft.
Okay, Andrew. Sorry, just because of time, and
yes, right, sorry.
we have about like 6 panelists on the panel. I'd want to go to StephX because he now deals on the other side of the asset recovery stuff. Now he deals with the tracing element, so he's the expert per se. So, Steve, how does it work on that side, which is not the legal side? So, what happens when the client comes to you? Who comes to you? Is it an institutional client? Is it a lay client? Or what does it happen?
I think for most part, I'll just give a general case. Most part, it's going to be, the victim that comes usually to a blockchain investigator. That's not as much what I do. I used to work for the exchange. So it used to be victims coming to the exchange and saying, hey, I was either a user of your platform and got scammed, or hey, somebody that is using your platform, I send funds to them and they're a fraud or a scam. So it's usually from that aspect. But from a general sense, usually the victim is going to come to a blockchain investigator just because, honestly, law enforcement doesn't have the capabilities or they don't have the resources to handle those situations. What that blockchain investigator is going to do is compile the information, similar to what Andrew's saying. They're going to compile all that information. They're going to trace the funds, and then they're going to have to go to the courts. Because even if they said, hey, and they have all that information, you can't go directly to an exchange with that information unless you're law enforcement. So what a lot of these investigators have to do is they have to create these cases, provide it to law enforcement, because the law enforcement unfortunately doesn't have the capabilities to do it themselves, and then request law enforcement to do an investigation using the information they provide. And then they need a seizure order. There's very unlikely that exchanges are going to turn over the funds, even with just a court order, even though a court order is pretty sound with the way that, I don't know, Andrew can correct me if I'm wrong, but even with a court order from a civil matter, some law enforcement, some exchanges won't turn over the funds unless they have a seizure warrant from law enforcement. And that's the biggest challenge is you can have all the information, you can have all the evidence, but the exchanges aren't going to work in your favor because then they're liable if they turn over the funds and they're incorrect, right? Then, a lot of people can go after them, especially with the volatility of crypto.
Yeah.
Thanks, Stephen. Keniel, you want to chime in on that?
Yeah, I just want to comment or add on to what Stephen was just saying in agreement, actually. So even representing the law enforcement side and having worked with a lot of agents and the crypto exchanges, you are right. Even if you do get to the point where you're quick enough to even identify these wallets, sometimes those source of funds aren't even there anymore. So by the time the victims report it, unfortunately, it is a shot in the dark. But the beauty is if there is enough information, we're able to trace and what we call substitute for assets. Sometimes you just have to go down that road if you can even get that far, where we do identify other source of funds or different wallets that they may have access and control to, that we were able to prove they actually have access to, and then seize those if we're even lucky. But you're right, it is tough, and that probably lends itself to probably better regulation, better laws on, with the exchanges in mind, how they may have to work on better consumer or user practices or safeguards.
And I'm not trying to say that law enforcement does nothing and, the first thing is to go to a blockchain investigator. There are law enforcement in certain jurisdictions, but they're few and far in between, right? Just like it's saying like, hey, who do you know that's a crypto accountant? There are some, but they're few and far in between. One thing I would add is because it's, not personal identifying information, you can actually call an exchange or message an exchange like, hey, crypto went to this address, hint, hint, nudge, nudge, it's from a listed activity. That doesn't necessarily mean that they, without a formal order, they're not going to do anything. But that does mean that they might slow down the process. If they see the funds there, if they do a quick investigation, they may slow down the process for the proper legal and court documentation to get them and law enforcement involvement. Doesn't happen all the time, but this is why relationships are extremely important in crypto, because you have to know who to call, when to call them, and the trustworthiness of you approaching them with that information.
Thanks for that. Lisa, I know you'd be interested in telling us about the consumer protection aspect of things, but just before I get to you, I'd like to go back to Keniel and Leah because they operate within the Caribbean and Latin American region. So how would you compare what Andrew and Stephen are saying in terms of the asset recovery process within the latter region in general?
I haven't seen that many recovery processes being widely publicized in Latin America as in the UK. I think UK and US and Canada are the pioneers in following up to successful recoveries through court action. But what I do see is a lot of education and do your own research going on within the Latin American public, because adoption happened in Latin America really fast because of community need of a trustable currency. We have a lot of volatility and political uncertainty in some of the countries here. So that's a trigger for the common people to adopt the cryptocurrency alternatives. In that sense, what we have seen is that there are regulated countries where the virtual asset providers are properly authorized and licensed. So institutions tend to obtain those licenses and come back to the countries that are not so widely regulated and start transacting. What we do have are anti-money laundering provisions everywhere and tax information from tax authorities, letting people know that whatever profit you do through cryptocurrencies transactions is taxable. And for example, in Colombia, from 3 years ago, every transaction over $150 gets reported to the supervisory authority for anti-money laundering. So it is it's evolving into a more financial transaction that it was originally. And as long as you do your research and people works with reputable providers, it is possible to get enough supporting documents, which is what your legal advisors and investigators will need to be able to help you into court with enough supporting documents. I think it's fortunately very far away the times that people will try to get into crypto with cash or in-kind transactions. And the more you do it through financial and traditional off-ramps with banking or financial institutions, the safer you are, because then you will have all the know your client and traceability of the transaction you were involved with.
Thanks, Leah. Keniel?
Yeah, I'll be brief because I kind of want to use this as a good and bad example. So when we had the instance of FTX, just based on what was in the public domain for the region, if we're going to use the Caribbean region as a factor. So prior to its collapse, if we were just based on articles that were put out there from public or individuals complaining. So if you're on exchange and say whether you got hacked or you got scammed into trading or giving your cryptocurrency over to another individual, if you did reach out, there was very little to nothing done in order to protect you or gain back your cryptocurrency on that exchange. Now, hindsight, right? Now that the collapse has happened, even watching to see how the funds are being liquidated and given back to those victims, you could see how there's been such an issue in trying to identify ways for individuals to be, to really safeguard themselves and have the exchange have policies and practices that'll help the consumer have routes or avenues for them to essentially have claims or gain back their funds that they put on this platform. So obviously it's a tough balance, because when you think of cryptocurrency, you do want to have safeguards where you're either anonymous or you're not centralized, attached to a banking institution or banking policies. Nonetheless, the reality is it is a fine gray area that we found ourselves in. But particularly within this region, we don't have great examples, because frankly, a lot of these institutions are using in Latin America and Caribbean as just for namesake, saying, hey, we're registered in this region for, sometimes I'm hesitant to say, but just to show these people that they're decentralized, that they're they're not tied to any governments, but, without getting into too much of it on this platform right now or in this particular chat, I do say sometimes they do it on purpose because they know they could get away with it, but I'll leave it at that.
So, Keniel, before you leave it at that, so what you're saying is the jurisdictions are being used for registration, but it doesn't percolate per se to the end users. So within these countries, so like Leah, for example, in Latin America, El Salvador has really been on the headlines for being vocal with Bitcoin and all that. But is the trickle-down effect really visible? Because what Keniel is saying, you're going to come and register in these countries without naming the countries, but there's no utility or trade on the ground per se. Andrew, I can see you're agreeing with that as well. But so whichever one of you, Steve, Lisa, whoever wants to clarify that point, like is it correct to assume so?
Well, I think it's the point which Keniel made, a very valid point earlier about the decentralization. So there is a sort of an authenticity, it might be said, whereas a cynic would say that the system is there to produce an effect of which it's very difficult to serve. It's very difficult to track them down. It's and as Steve rightly said earlier, sometimes even if you track them down, it requires the local enforcement, the regulatory bodies, to effectively ensure that payment is made. So it's I've read here in England, after that Deloitte case, there's been a few articles where effectively rather pessimistic tone to them, saying it's very expensive and very difficult. But the reality is that the nature of the decentralized exchanges is such that it's bound to be. It was never going to be easy. So
Thanks,
yeah.
Andrew. Lisa, Keniel, Leah.
So if I could just quickly comment on El Salvador. So I was there just for about a week last year around the same time, and I ended up informally meeting with law enforcement there, one or two individuals that identified themselves as tech or fintech entrepreneurs, and the conversation that was had is, even though it is the official currency, you're not seeing it still utilized because there's other underlying issues, whether it's infrastructure, legal framework. But I do wish, and I want to see more of that, because essentially for it to be more legitimized, I do think you need more people and institutions involved. And I think for the country just to say, hey, we're going to enact this and not have a lot of, say, businesses, individuals having the technology or access to financial means to utilize a cryptocurrency, a lot of things just won't work in general. Haven't only seen that for about a week, but I was on purpose searching for businesses that I could, with my Coinbase wallet, try to buy something. But unfortunately, I was not successful. But allegedly, most people just, when they got that free $10 or $100 from the government, they just offloaded and went and bought groceries, from what I understand. I might be wrong. Correct me in the comments. I don't know.
Well, about El Salvador, maybe it's true that Bitcoin transactions aren't that big as it was expected when the law was created, but From the legal and investment advisor point of view, the fact of having one country recognizing Bitcoin as legal tender and a currency was a big advancement, because that was enough for other authorities and other countries to start treating it as an asset to be taken on account for financial transactions. And for example, in Colombia, there are banks, big banks, that have subsidiary banks in El Salvador. So it was a lot of work for them to, in such a short time, get ready to transact with Bitcoins within banking regulations. What they did, and from that learning, the rest of Latin American banks is getting a lot of experience. And right now, there are many banks offering for their VIP clients, or for those cases with sandboxes. In many Latin American countries, the authorities, the financial authorities, have launched sandboxes for financial institutions and virtual asset service providers to get together, create their minimal viable products, and think together how to regulate it to make it available for the common public. Because what you said, you were seeing before, was either the common people were very risk affected by doing transactions by themselves, kind of underground, or only those with enough funding to hire big shot consultants that got access to, reputable custody services and advisors, were getting the benefits from the blockchain itself as an equalizer of opportunity. So I really like to think that as long as financial institutions create wallets and services tailored to the common people, it will create that certainty that will allow people to really adopt the cryptocurrencies in a safe way.
Thanks, Leah. Lisa, we've been waiting for you. You sit in the House of Lords. This is where it all happens.
No, the House of Commons.
You're bubbling.
You've just promoted me.
So, Lisa, tell us what happened in terms of regulation and all the build-up in the UK. How is Parliament thinking of this, and what's the evolution of
yeah.
the whole thing? Yeah.
I mean, when I was in the House of Commons, as you say, very common, certainly not a lord, then it was something that we really needed a lot of education on, to be honest. I felt like the public were way ahead. Many people who were involved in cryptocurrency, over 4 million now in the UK, knew much more about it than the MPs in the Parliament. And when we started in 2021, there had been absolutely zero debates in the House of Commons at that time on this issue. So the idea was to educate ourselves, try to understand what was happening, why it was important, but also about the risks. So looking at opportunity and risks, and trying to put consumer protection at the core of the work we were doing. So I got involved originally because one of my constituents contacted me and said he had lost money, and we I now know this was a rug pull scam, and he had lost money but didn't know how to get any redress, and said, can you find the person in Parliament who's working on this? And of course I said, well, yes, I'll go and find the person and put you in touch with them, whichever MP I thought might be doing this. And we couldn't find anybody, so we had to kind of start from scratch at that point. And during the last 3 years, we held the first joint inquiry between the House of Commons and House of Lords through the all-party group into cryptocurrency, and also looked at why regulation is very, very important for protection of consumers, but also really for clarity for investors as well. So, I think it's actually important for the industry. That became very clear to us, that it's important for industry to have that clarity. Now, I'm very interested to hear the actual on-the-ground experiences that people still find it very difficult to get redress, because industry would often come to Parliament to tell us that with blockchain technology, this was very traceable and trackable, and therefore, the opportunity to scam was actually quite low level compared with, cash and other types of finance transactions. So it's interesting to me to hear that the actual people who are tracking this and trying to get people redressed through the courts are finding that, it's very, very difficult, that the laws are probably not where they should be as yet to enable it, and certainly not for the ordinary person to be able to afford to take these cases forward yet, and the sort of legal precedents are not quite there yet, although they're coming forward now. So I think there's still a long, long way to go. And as you said, it's very global, this, it's not just that it's happening in silo in the UK. Companies or global companies maybe set up in other jurisdictions, or have setups in multiple jurisdictions. So from the group that I run in the Parliament, which was very cross-party, and as I say, members of the House of Lords and the House of Commons, we've moved now to me looking at setting up a global group of legislators who will learn about the sector and who will look at global best practice standards, because we felt that this was absolutely missing, actually, but very, very crucial, because this is an international issue as much as it is for the UK or anywhere else. Yeah.
Thanks, Lisa. Now, I'm going to ask a broad question to the panelists. So, in your respective jurisdictions, starting with you, Stephen, what would be the ideal scenario for you, for companies, for startups, for innovation, for ordinary Jane and Joe Doe trying to get into this industry? I'm sure you know about the Quadriga case and all the things that happened back in Canada. What's your ideal way out of this and future-proofing this industry moving forward? And this applies to all the panelists in your respective jurisdictions. So starting with you, Stephen.
I think Canada is interesting because we have emerging regulations, especially around stablecoins. I think the government wants to treat stablecoins like some of them like securities. And that's that's like dampening the whole reason why you would use stablecoins. Like imagine you had to, get a prospectus every time you want to send 100 USDT around the world. It doesn't really make sense. It's like, being allowed to go to a high school party, but your parents are chaperones. Like you're excited, but you're not going to be able to experience the full potential of that party because your parents are there. And that's what Canada feels like. And, credit to the players that are here because they've had to go through a long regulatory process and they've done great things. And that's why you see a lot of foreign crypto exchanges either exit Ontario and other places because the regulatory strain is too large. We also have a Retail Payments Activities Act that's coming in that might coincide. I wrote some points down here, but it's just pretty much to sum it all up, more burdensome registrations and compliance And in my opinion, and I don't speak on behalf of a bunch of Canadian, I don't, I spent a lot of my time working in international exchanges. In my opinion, Canada's market doesn't seem as big as like a US market, where if you can, get in here, do all the regulatory obligations, you have this huge pool of digital assets and people interacting with it. Canada doesn't feel like that place, although the places, the crypto exchanges here are doing very well, and they're evolving and they're large, but you're seeing a lot of merger and acquisitions. WonderFi is doing a great job of having a whole bunch of auxiliary services. But to me, Canada is exactly like that. It's a great place to go if you like playing in regulations and you want clarity for the most part, similar to, I'm assuming, the EU. And unlike the US, it's not as vague, but it's also very burdensome, and it may not be the most ideal market unless you're already based in Canada as a crypto exchange.
Keniel, thanks, David.
Oh, for sure. I definitely agree with Stephen, and also want to touch on a point that Leah brought up earlier today. Maybe just jumping ahead, in order for this to work in globally, I do think we have to go back to the concept of probably how financial institutions are regulated, because if we want to talk about protecting the consumer, but yet having a equitable platform for all its users, from all standpoints, from a trading or probably from a legal or law enforcement standpoint, maybe a lot of these exchanges should be treated like financial institutions. And you're right, in the US, it is still very vague. And I think that's why a lot of countries, probably not the EU, have been hesitant to onboard or identify ways for them to generate enough policies or legal legislation to cover a lot of these platforms, is because a lot of them don't have the framework, or are kind of probably waiting for the US and the EU to be a little firm in what their expectations of these platforms should be. But Leah brought up a good point. But if there was an opportunity to involve the financial institutions on the onboard, and because there's already common reporting standards that already exist that covers financial institutions, maybe that's another platform. But then you had to say, for example, like a Binance, all you need is an email, but it doesn't matter who's behind that email. And then you had institutions like Coinbase that was heavily regulated in the US, where they treated you like a banking customer. You wanted photo IDs, you wanted a pre-existing bank account, you wanted, your mother's maiden name, like everything about you. But then some people were sometimes turned off that. So is there a middle ground? I'm not sure, but for the sake of regulation and being a platform that almost covers everyone, being anonymous, being decentralized. Maybe we're trying to cross too many things at once, which makes it so much harder to regulate these entities. But if there's one thing I could comment on, if there's a way to probably have, and I do think it's coming, as much as I'm part of the Department of Treasury, it is coming. It's a matter of trying to get also the social perspective, what people are really saying, as probably as this president election finalizes and all the candidates identify, as well as the Department of Treasury, FinCEN, Financial Crime Enforcement Network, have better ideas and some of the information we have collectively, I think then we will probably see a more heavier stance from the US. Not to say there isn't, but right, it has been vague, because right now it's just treated as property, and we're applying what we call yesterday's laws to today's new innovation, which is tough.
Thanks, Keniel. Andrew?
Yeah, what Keniel was saying, I echo entirely. Here, there was a recent report by the UK regulator, the Financial Conduct Authority, FCA, that effectively, and they were referring to KYC governance, and it was like a tick box exercises, and it had resonance with what Keniel was saying earlier, and of course the thrust of the report is that, in future this isn't sort of a tick box exercise. It's got to be real. It's got to be substantive. So there's that would assist consumers. I think also in terms of financial promotions in England and Wales, certainly are regulated now. Lisa referred earlier to consumer protection. Obviously, that's the foundation of it all. But the new government here in in the UK, that they're pushing for outward investment into the UK. So you've got, to some extent, there is a potential conflict. So which way that's going to go forward, and of course it rails against some judges' approach, which is essentially that a number of these exchanges should be treated as a reputable high street bank. So there's a lot of tension. There's a tectonic sort of plates that are rubbing against each other at the moment. So it's interesting.
Andrew, before I let you before you pass the mic on, the issue of the exchanges being treated as financial institutions has been kind of dealt with in some of the legal precedent, and I think you acted in one of the matter before Pirazude, and there's always this thing that the exchanges are always liable, but then the Pirazude case came about and it kind of flipped the tables, because Pirazude said you need to assume that the exchange is a financial institution, and surely you can't be suing the banks all the time if things go tits up in the
no, Pirazude, absolutely, but I think that didn't really or that judgment was I've got it here in front of me actually. That judgment was handed down. It was published. Tell you exactly when it was. It was the 2nd of March 2023. So obviously, FTX really hadn't kicked in at that stage to the extent that it has, and I suspect, this is my personal opinion, I think other judges, with the passage of time and knowing what we know now, would perhaps take a different view as to the exchange itself. Now in Pirazude, the application for at the return date of the injunction proceedings, the judge dismissed the claim because he took the view that the exchange were good for their money, so therefore damages were an adequate remedy. So there's no need for an injunction, a freezing injunction. That was the main problem, but also as well, it dealt with the issue of, which you in English common law, the common law tracing process if there's a mixed fund, and the issues that arise in respect of that. Whereas some exchanges, and it was US Dollar Tether and Binance were the exchange, and they said, look, this is all mixed, it's pooled, tough luck, there isn't any proprietary remedy. Whereas other exchanges, I know, because I've seen their standard terms and conditions, they will say that there is no mixing and they're not custodians of anything, and so essentially it is pigeonholed, and the crypto currency or the crypto asset will still remain, title will remain with the original investor. That makes it a lot easier to obtain a proprietary injunction. So essentially, the point I'm making, Brian, is that post-Pirazude, there have been efforts which have been successful to effectively distinguish it and to take the sting out of what was seen as pretty catastrophic at the time when it was first published, as you rightly say.
Cool. Thank you, Andrew. Lisa?
Yeah, I mean, there's been a lot of different legislation come through over the past few years. In the UK, we had the Financial Services Markets Bill, the FinProm regulation. Last week, we had the Property Digital Assets Bill. So cryptocurrency will be considered like personal property. I suppose that means it can be split up during divorces moving forward, if need be. But it should afford some additional legal protection as well. But I think it's such a complex issue we're going to have, and we don't even know really with the new intake of parliamentarians the level of knowledge already pre-existing there, and how much kind of educational component needs to be undertaken just to understand the sector in a sense. And it's huge. I mean, it's huge as well, because when we started, we were looking purely at finance, and then we had we were able to go over to Crypto Valley and to get some induction there, and they were explaining, and we since learned that this whole digital revolution isn't just affecting finance, it's affecting art and sport and fashion. I mean, I opened a digital fashion conference in London just 2 weeks ago for Fashion Week. So I mean, everything, the way we live our lives is all becoming very digital, and there's going to be tokenization. There's companies. I went to visit an amazing apartment in London that's been tokenized. So property, there's a huge amount that's going to be happening that actually legislators, we need to help to inform in a very balanced, objective way, rather than, which is why, it's very important that we do have the ongoing all-party groups in the Parliament, but also we have this global network that I'm in the process of setting up, because we can learn about best practice from other jurisdictions as well. We've already, but I've been out to visit VARA, and I know there was a mention about inward investment as opposed to consumer protection, and I think it's getting that balance. And I know when I spoke to colleagues at VARA in the UAE that they were saying that they do wear two hats in a sense, but the FCA doesn't. I mean, it's it's about consumer protection, but I suppose government will also be looking at potential and the jobs economy as well, and the digital economy for jobs coming to the UK. So it is quite a fine balance, I think, and underpinning it all, I think, in the when I'm looking at the parliamentary context, is going to be the education component. I mean, if I give you a very quick example, because of time, we had an event in the Parliament just about the digitalisation of our world, and one of the questions, there were MPs in the room, there were members of the House of Lords, and there were members of our youth parliament, the Children's Parliament. And one of the questions was, who understands Web3? All the children put their hands up in the air. No members of the House of Lords, hardly any MPs. So, it's a very generational thing, and we have a lot of work to do to upskill our parliamentarians. And certainly I had to, go through and learn and read, and it's such a fast pace of change as well. So we've got a lot of work to do to keep parliamentarians abreast of changes and make sure that we can get robust legislation that means there's not a race to the bottom in the UK.
Thanks, Lisa. And
Brian, before we go on, I just want to quickly say that we have to remember, like, as much as legislation and regulations make sense, and we have to do better, the banks are the de facto regulator. So if you're a crypto exchange and say, hey, we only need one piece, regulators say you need one piece of ID and that's it, and you can onboard your customer, but your banking partner says you need two pieces of ID, guess how many pieces of ID you're going to ask your client for? It's going to be two. We don't talk about this enough. We focus so much on regulation, but just remember, if you want to be in this digital economy and world and you need to do cross-border payments, whether in crypto, you're going to need to settle most likely in fiat, and your banks are going to be the ones that are going to be telling you exactly what you need to do to keep a banking account. And you can ask all the top crypto exchanges what their biggest fear of from one day to another, and it's their banking relationships being lost. And we've seen that with several of the exchanges that ran into trouble in the past. So I just wanted to make sure that people remember that too. It's like regulators can say whatever they want. The banks will be the de facto regulator, I think, for a long time.
Yeah, but Stephen, Leah, just one second before we progress. Stephen, what you mentioned is very interesting, because ideally, we're supposed to be moving from that banking world with decentralization, because, value transfer, decentralization, blah, blah, blah. So where exactly are we, Stephen?
You can either be decentralized or you can run a profitable business. You have to decide which one is more important to you. So as much as we want to be libertarians, I've never seen too many libertarians making a ton of money. That's why you're seeing everyone go the traditional route. But I want to hear what Leah was going to say. She was ready to jump in there.
Leah, then Keniel, please.
Yes, well, the thing is that here in Latin America, we have a different view of what blockchain transactions can help us do. For example, getting some sort of universal identity for migrants, and then granting very small credits to those individuals until they settle and can fit into a more transactional banking-like experience. That has been a successful thing that has happened. I have clients and colleagues doing that in Latin America. So you kind of graduate your migrants into recognized individuals, and then they have some alternative credit scoring measurements, and you can help them get into the traditional banking system. And then remember that banks do not ask for 2 or whatever requirements of identity or anti-money laundering requirements just because they want, but because the regulation requires that. So it's there's no one size fits all, and you have to keep self-regulating with very strong ethical principles and trying to fit current transactions and relationships going on with the legal framework you have on hand. And as it keeps evolving, just adjust your services or transactions into what regulation will keep asking you for.
Thanks, Leah. Keniel, and then we'll have a round of takeaways from the panelists, and then possibly if there's any question from the audience, we'll get to that. So Keniel, before we go to the takeaways.
For sure. So I'll definitely keep it short to this one point, because I definitely agree and see the mindset. So I love it. Yeah, it's always the cart before the horse, or is it the egg or the chicken? It's who's regulating who. But I will just say this, in a probably agreement with Lisa. I do think at the end of the day, it is good to know, for one, what the rules are, right? So if we have proper legislation, we have proper policies, I think business will thrive better because they know where they stand, whether it's on the left or the right, and definitely not in the middle, the gray area we call that, right? So I think with that said, if we could improve or come together as a globe, whether it's the EU, US, Canada, and set these, because this is where you have to also think where the businesses are going to essentially domicile, but where the clients or consumers are going to be. So essentially, if the rules are clear and the agreements are there with these governments, I think they will all thrive. But nonetheless, it is education. I do feel that we haven't, in my humble opinion, the US haven't thrived the way we should because there is a lack of education, lack of know-how. I do agree that the younger generation, the generation growing up now, are way more tech savvy, and they utilize technology way more than we would have ever. So with that said, I do think it's more at knowing policy, having clear legislation and policies, and better education, educating the masses.
Thanks, Keniel. So I'm gonna go back to Lisa. Lisa, we're gonna start with you with your takeaways. So just imagine 10 years from now, somebody's watching this YouTube video. So you're talking to the future kids and them. So what's your piece of advice, or to the people who are gonna watch the catch-up video? What's your piece of advice to them?
Yeah, I mean, I hope 10 years from now that the progress has continued in the Parliament. I think it's just been very crucial that we started that work when we did, because our world is it's going to be a digital world, digitalization, and it's a global aspect to this as well. And I think that we need to have that shared best practice, and we need to give young people the skills so that they can make the most of their potential from this new technological advancement, and to make sure that they can fulfill all of the opportunities that they should with it, because although we've been speaking about bad actors, there's also a lot of opportunity for good and progress as well.
Thanks, Lisa. Leah?
I'm happy to see that it is clear now that blockchain and cryptocurrencies are not besides or away from law enforcement, and that if you use such technology as a tool for evolution and a better way of life, it's fine to keep adjusting to regulations. And if you attempt to use it against the public, there will be ways for authorities to prevent you from doing that anymore.
Thanks, Leah. Andrew?
In 10 years' time, my hope would be that, as Lisa said earlier, that education has been key in the last, as it were, 10 years. The master of the roles at the moment is Jeffrey Voss. He's very keen on a virtual assets, digital assets court. So I would hazard a guess in 10 years' time, there will be such a court, and Gen Z will have taught the rest of us the ins and outs, and we'll all be better for it.
Thanks, Aaron. Keniel?
So if I'm speaking to the Gen Z or the Gen Z, well, I too was born in the 1900s, as they would say, but in all seriousness, I think the most important thing is the global approach, where we have governments, private institutions, and other exchanges that are working together to essentially develop these these policies and these laws, and and working with law enforcement and different governments to identify what's the best practice for everyone, with the consumer in mind as well.
Thanks, Keniel. Steve?
I think you see the diversity on this conversation. I think that's what we need when it comes to making regulations. We need to we don't have to all agree here. We don't all agree. We all have our personal perspectives, our jurisdictional perspectives, and I think that has to come into the conversation, because the reality is a lot of this stuff is going to be figured out not by regulators, not by the blockchain industry, and Andrew probably knows this better than me. It's going to be figured out in the courts, right? 10 years from now, a lot of these, we can pontificate, and it's amazing that we're having these discussions, but it's going to be a judge that eventually either sets a precedent or makes a ruling. Like the SEC didn't approve Bitcoin spot ETFs because they wanted to, or because they were having a decent conversation with the blockchain industry. It's because they were forced to by the court system, and they fought tooth and nail. And I think we're going to see a lot of that as we try to, offer an alternative financial ecosystem.
Thanks, StephX. Members of the audience, if anyone has a question, just feel free to put your mic on and shoot a question. We're going to leave it open for the next 30 seconds. If there are no questions, we'll proceed to wrap up the session. Yeah, it's okay. I guess there are no questions from the audience. So I'm so grateful to the panelists and for all the people who've attended today. It's been a brilliant conversation, and thank you so very much for your time and for sharing your knowledge. And we really, really look. Oh, there's a comment here. Sorry, guys. I'm gonna do that wrap up again. Thank you, Anya. Thank you, Winifred. I guess there are no questions, but the members of the audience are really grateful as well. So thank you for your time and sharing your knowledge and wisdom with us. If any members of the audience want to pick up a conversation with the panelists, they are all on LinkedIn. You can find Steve Sargeant, Keniel Ledgister, Andrew Maguire, Lisa, Leah. You'll find them on LinkedIn. Thank you so much for your time, and we hope to see you next time for the next Crypto Mondays Caribbean webinar. Thank you all very, very much. That's it for today. Bye-bye.
Thank you, Brian. Great job.